the sound is freezing. I don't only in my computer and for everyone. Sometimes I hear and sometimes I doesn't hear.
Well, Carol, we can listen to you perfectly. We have
Okay.
our audio and image 100%. And
Okay.
we'd like to welcome you to our university. So we have the 4 lecturers. Of course, the first lecturer will be Professor Gerhard Fiolka from University of Freiburg. I think it's the correct pronunciation, Freiburg. It's correct, Professor? Yes? From Switzerland. And he's going to talk to us about international criminal law and human rights. In the second part, we are going to have Professor Edita Figura. Polish names are very difficult, very difficult. Yes, Goralczyk.
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 The second part.
Yes.
Figura. So it's enough figura, let's say.
Yes, it's better figura. It's more easier because Polish names are very similar to Russian names, very difficult names for us Latins to talk. Well, Professor Edita are going to talk to us about contemporary challenges of consumer law in times of pandemic COVID-19. The third one, it's Professor Carol. Your family name, it's also difficult for us. How do you pronounce?
Maybe you can try it first. Because
oh my God.
Yes, it's difficult, but we are going to learn. We learn, but it's, how do you say?
I ask you to try firstly because it's very funny for us.
Yes. Yes. Just to make fun. Of course. Well, for
bullying.
Me, I would say Ruskowski.
Ryszkowski.
Ryszkowski.
Yes.
Yes.
Ryszkowski.
It's
Ryszkowski.
Yes. It's more or less because because I go more or less like the Russian names. I try more or less. Well, be welcome, Professor Karol. And Professor Karol will be talking to us about fundamental right to property in Polish law. And at the end, we are going to have our professor from North Macedonia, Goran Ilic. Professor Goran is going to talk...
Hello to all.
Yes?
Hello. I said.
Yes. Difficult names, but we learn. Well, is going to talk about memory, identity, nationalism, and European regions. I think it's a very special evening. Of course, it's you can speak in English because we understand. We have another people that I would like to make my thanks. So I ask just to talk in Portuguese for a few minutes. I would like to make some thanks. Eu gostaria de aqui também registrar os agradecimentos para a reitoria da Universidade de Itaúna, na pessoa do professor Faisal David Freire Schecker, que é o nosso reitor. Também os nossos agradecimentos para a coordenação do nosso PPGD, mestrado e doutorado, na pessoa do professor doutor Márcio Eduardo Senra Nogueira Pedrosa Moraes. Também igual agradecimento à coordenação do curso de Direito da Universidade de Itaúna, que é a professora Lilian Nassara Miranda Schecker Bueno, bem como ao professor Fabrício Veiga Costa, que é o nosso coordenador adjunto do curso de Direito da Universidade de Itaúna e também professor do PPGD. Os meus agradecimentos ao Centro de Excelência Jean Monnet e Rede de Pesquisa, Integração, Estado e Governança, na pessoa da professora Jamile Bergamachini Matadis, que está sempre apoiando os nossos eventos. Dando sequência, também os nossos mais sinceros e profundos agradecimentos ao Grupo de Pesquisa Metamorfose Jurídica e Universidade de Caxias do Sul, na pessoa da professora Cleide Galgaro, que está sempre conosco, é a nossa parceira acadêmica. Também há uma outra parceira acadêmica que eu já estou fazendo aqui um spoiler já antes do seminário, que é a professora Mariângela Guerreiro Melhorança da Rocha, que está fazendo aniversário hoje. Já estou fazendo esse spoiler, mas nós ainda temos mais um aniversariante, que eu descobri hoje, que é o professor Gerhard Fiolka, que também está fazendo aniversário. Então nós temos 2 aniversariantes, que estaremos aqui no finalzinho fazendo uma pequena celebração, né? Mas aqui eu gostaria de deixar o meu agradecimento ao Grupo de Estudos Araquém de Assis, o GEAC, da Faculdade Meridional e MED de Porto Alegre, na pessoa da professora Mariângela Guerreiro Melhorança da Rocha. Também aos nossos parceiros, aos nossos amigos da Escola Superior Dom Helder Câmara, na pessoa do coordenador do PPGD, professor doutor Magno Federici Gomes, que também está aqui conosco, sempre participando das nossas atividades. Estamos muito honrados com a presença da pró-reitora de pesquisa da Escola Superior Dom Helder Câmara, que é a professora doutora Beatriz Souza Costa. Muito nos honra a sua presença, professora. Seja bem-vinda.
Parabéns a todos.
Sim, e agradecendo também aqui os meus colegas que eu pude observar, a professora Luana Pedrosa, que se encontra presente. Observei também que a professora Renata Mantovani de Lima também se encontra presente. Os meus agradecimentos a todos que aqui estejam presentes, caso eu tenha esquecido de nominar algum nome, mas também gostaria de dar as boas-vindas a todos e todas aqui presentes nesse evento virtual. Bom, antes de dar início, eu gostaria de passar a palavra para o professor Márcio Eduardo Pedrosa Moraes, para que ele possa fazer algumas considerações, e logo após nós já iniciaremos com o professor Gerhard Fiolka, da Universidade de Freiburg, da Suíça. Professor Márcio.
Boa tarde a todos. Eu gostaria de agradecer a presença de todos, ainda que remota, e diante das circunstâncias fáticas que não nos permitem outra situação que não seja essa. Quero aqui, vou quebrar o protocolo, professor Deilton, e eu já vou externar, então, os parabéns, os cumprimentos à professora Mariângela e ao professor Gerhard Fiolka, inicialmente desejando-lhes muita saúde, que Deus esteja ao lado de vocês durante todo o resto da vida, que seja uma vida longínqua. A professora Mariângela já é uma amiga mais antiga nossa aqui, está sempre nos apoiando, é uma pessoa muito próxima, assim como também tenho a honra hoje de me tornar, digo, amigo, né, de professor Gerhard Fiolka. E quero aqui já dizer que nessa semana, especificamente hoje, nós assinamos mais três convênios internacionais. Eu gostaria de deixar isso claro também, professor Deilton. Nós assinamos um convênio com a Universidade de Saragoça, na Espanha, assinamos um convênio com a Universidade de Baiano, em Cuba, e assinamos um convênio de dupla titulação com a Universidade de Alicante, na Espanha. E é muito importante isso para nós, porque nós somos uma instituição pequena do interior de Minas Gerais, e nós estamos aí já estreitando laços com outras instituições estrangeiras. Já temos alguns convênios internacionais, mas esses convênios que assinamos hoje, eles se juntarão aos que nós já temos, e em breve quiçá nós teremos outros convênios internacionais para que seja uma oportunidade de troca de informações entre continentes. Gostaria então de dizer que pedir licença, que vocês não entendam isso como uma falta de educação, mas infelizmente eu não poderia ficar até o final do evento, professor Davidson, porque como aqui os professores do Brasil sabem, tem a responsabilidade no preenchimento da sucupira, e a sucupira está fechando, e que eu estou nesse momento aqui terminando a conferência do nosso relatório. Então, infelizmente, eu não terei condições de ficar. Peço licença a todos, desejo a todos um excelente seminário e agradeço, então, a presença de todos. Devolvo a palavra para o professor Deilton e declaro, então, abertas as atividades de hoje. Muito obrigado, professor Deilton.
Pois não, professor Márcio, somos nós que agradecemos. Sinta-se à vontade, caso necessite nos deixar, mas gostaria então de agradecer aí a sua presença, o seu apoio, né, que isso é muito importante para que esses eventos eles continuem a acontecer. Fico muito grato. Eu peço então licença aos demais para que a gente possa se dirigir aos palestrantes, né? E Professor Fiolka, now it's your turn for your lecture, but before you talk about your lecture, I would like to remember when I first met you. We were at Salamanca University in Spain, and you were talking to another colleague, and I had a small opportunity to talk with you. It was a very brief conversation, but very significant, very important, because I never forget you, Professor. And of course, after this pandemic situation, we are going to invite you and all of you to come in person to Brazil. In our University of Itaúna, we have a tradition. Our tradition is that each lecturer, each professor, each foreigner professor has to plant a small tree, a very small tree. Because our university is very big, we have very big gardens, everything green. And you are going to plant a tree, and you are responsible for this tree, of course. So from time to time, you will have to come to our university to see how is your tree, if everything is okay with your tree. It's our tradition. We already have many trees planted, and of course you have your opportunity to have the tree which will have your name. Well, for the lecture, we ask about 25 minutes. You can be free for your speech, for your lecture, and we are very glad, and it's a pleasure and honor to listen to you. And I think it's a first meeting, but not the first one, because other meetings will happen in the near future. So the word is up to you, Professor Fiolka.
So thank you so much for that very kind introduction, and also, of course, for the really nice prospect of having a tree in Itaúna one time. So this is really something that warms my heart. So this is very special, and it's also very special to be here tonight with you. So thank you very much for having me. It's really very touching that you thought about me, and I'm very happy to be able to talk to you this evening or afternoon. So thank you very, very much for having me, and for that kind introduction. I will now try, I'm using Google Meetings for the first time to share my slides.
You go to one window and open.
Yes, I see.
And then share. Yes, it's working correctly.
Oh, that's nice.
Yes,
So
and you can
will
expand if you want the slide. You can expand.
Okay. So, I would like to talk now. I don't really see myself right now, so if I do anything really embarrassing, please let me know. So I was asked to talk to you about international criminal law and human rights, and I will talk about three things here. First of all, what is international criminal law actually, as I'm the only criminal law guy here in our virtual room. Probably it is not that useless, because after that we will have to talk about how international criminal law actually works and what the effects of international criminal law are, and then we will see that the relationship between international criminal law and human rights is a complicated one, actually. One might think, well, easy. International criminal law actually is there to promote human rights, but we will really have to think if international criminal law is able to promote anything at all, and if focusing too much on international criminal law might not be problematic in the end. So a very brief reminder of what international criminal law actually is about. Traditionally, we talk on substantial international criminal law. We talk about four traditional so-called core crimes. Those core crimes are held in the Rome Statute, and they are the crimes where the International Criminal Court in The Hague would be competent. So we all know genocide is
Professor
a very
Fiolka, because
Yes.
I think your slide, you can change your slide, because it's showing to us only the first one, because I know that you are changing subjects.
So do you see something different now?
No, just the first one, which...
That's not good.
yes.
So I'll try again. Now I do something different. You see a slide now?
Yes, and I think it's written International Criminal Law, Substantial. Now you change it. Substantial, application, based.
Looks better.
Yes.
Looks like the things I am sharing. So you didn't miss much yet. No problem at all. So we have the genocide, we have crimes against humanity, war crimes, and quite recently added to the Rome Statute with open perspectives, the crime of aggression. Those crimes are based mainly on treaties. We have a treaty on genocide convention, UN convention. We have the humanitarian criminal or the international humanitarian law that deals with war crimes. Then we have the UN Charter, where we have the ban of aggressive warfare. And crimes against humanity, we don't really have any specific treaty law as yet, but there are plans on introducing that. So there is a lot of treaty law around in the field of international criminal law, and this treaty law has also been implemented into different legal orders all over the world. So, for example, in the Swiss Criminal Code, we have genocide, crimes against humanity, war crimes as well. We didn't implement the crime of aggression in the domestic criminal code. And then, of course, one of the drivers of the development of those core crimes is the Rome Statute, because in the Rome Statute they are defined, and they are defined for the International Criminal Court. But in the Rome Statute per se, you only have the competence of the International Criminal Court. You don't really have a duty of actually enforcing those crimes to the states. So, further question, who has to bring this substantial international criminal law to life? Who has to apply that? And of course, the main burden of the application of international criminal law is with states. Usually, states directly involved in crimes will not be able or might not be willing to prosecute. They might have problems in their legal systems that leads to shifting the burden to other instances. Of course, any other states might jump in and take that burden of adjudicating international crimes. And then, of course, there is the International Criminal Court, but then, of course, the International Criminal Court only can deal with most important and most grave cases, and is probably it wouldn't be a good idea to rely entirely on the International Criminal Court, because we have seen it's a relatively heavy, relatively slow at time mechanism. And so, of course, there are other instances in applying the international criminal law as well. There are some hybrid courts where you have a blend of domestic and international elements, but this is kind of the panorama. Further question linked to that question of application is who actually has the competence of dealing with international crimes, because you often have to claim that international criminal law should end impunity, impunity of those crimes should be avoided. But of course, there are different fields of application. We have territorial jurisdiction that very often doesn't lead very far, because there are problems in the judicial system of a state where those grave crimes actually are perpetrated. Usually they are linked to the state system in some way. So there have been claims of universality, so that there should be no safe haven for a perpetrator of international crimes wherever. So it should be possible to really start a trial on international crimes, core crimes, anywhere in the world. So people should never be safe from prosecution. But if we look at it more closely, this sometimes pompous claim of universality is reduced to what we have in domestic jurisdictional law, but also in the Rome Statute, it's reduced to the idea of complementarity. So the International Criminal Court, but also states, usually establish jurisdiction and establish the competence to judge on a certain behavior that happened abroad when states more directly involved are not able to or are not willing to take on those procedures. So now the difficult question after those introductory words. The question is, what does criminal law, and hence international criminal law, actually protect? Because if you presume that international criminal law should be linked to the protection of human rights or maybe of the environment, then one quite automatically thinks, well, criminal law protects, adds a certain layer of protection to other legal measures taken to protect something or to prevent certain behavior. But I'm always a little bit embarrassed when I'm when I'm talking about criminal law, which is actually my field of activity, because criminal law is always a reaction to the past wrongdoings, to past crimes, to past breaches of rules. It's always looking backwards. So it's always late. Never anticipates anything, is actually barred from anticipating anything. I mean, if you look at drama, television series, then sometimes you have a person that is probably in danger or is in fear, and then there is usually some lines of dialogue. Do I really need to get killed before the police will act or will protect me? And if you look at what criminal law actually does, the answer would be yes. Criminal law actually is interested in your case after you have been killed. So criminal procedure and punishment don't really have any preventive effect per se. And criminal law, domestic criminal law, international criminal law, doesn't actually protect anything. That, of course, is not very satisfactory. So we have to try. So we have built a bridge from the past to the future. Because the main idea would be, well, because criminal law rules exist, because criminal procedures take place, and because perpetrators are punished, others will refrain from criminal behavior. And therefore we have some kind of preventive force of criminal law. But there is a problem to that. If you look at what criminologists say, of course the effectiveness, the idea of deterrence of criminal law has always been something that's been at the focus of what criminologists actually do. That's what they are really interested in. So they have been studying this subject for years and for decennia, but it has been really, really hard to prove any deterrent effect of criminal law whatsoever. So the amount of the punishment, of the sanctions, doesn't really count. Probably the probability of being tried is more important than the actual sanction, but it's really been hard to prove that criminal law has any deterrent effect whatsoever. One problem there, of course, and nevertheless, me as well, all of us, we think, well, criminal law, of course, we don't do things because they are forbidden. When I came to the office today, I put coins in the parking meter because there could be a fine if I don't. I put on a mask when I took the train because there could be a fine. Well, I was sitting more or less alone in the compartment, but still I had this face mask on because there could be a fine if I didn't put it on. But it's really hard to separate analytically the actual norm and the appellate function of the norm and the effect of criminal law. And we very often perceive preventive effect of criminal law where we actually don't have a very strong incentive, where we don't have a pull factor to commit crimes. For example, I haven't killed anyone in my life yet. Raped anyone. But probably not because I think I could be imprisoned for doing that, but because I don't think that those are things one should do. I think those are really, really problematic, despicable acts, and so I didn't do that. And well, usually I tend to think that I park my car in parking spaces and I don't drive too fast because it's forbidden. But on the other hand, if I really try to think about it more closely, I'm not that much interested in doing that. But if you think about parking your car in a place where you shouldn't, as long as there are enough parking spaces around, not much of a problem. But if you are in a hurry and need to go to an appointment, and then you will quite easily put your car somewhere where you risk a fine. So the problem is that criminal law is perceived to be deterrent, but the effect only works in cases where people don't really want to commit crimes or are not really in a situation where they would feel pressed to commit crimes. So in the end, the main function criminal law, the main effect criminal law actually has is it is a formalized reaction of society to specific unwanted behavior. So it consists in some kind of actualization, I'd say, of norms, of rules in society. And here, of course, we have a problem of verification, of scientific verification as well. It's really not, it's not neither possible to falsify nor possible to actually prove that effect, but that's the most plausible, I'd say. But if you really want to have evidence that criminal law works as a deterrent, already on the level of domestic criminal law, you won't get any hard evidence of that. Then in international criminal law, we have lots of further problems that cast serious doubts on the effectiveness of criminal law. The obvious thing is some perpetrators act out of conviction. They think that they actually need to win that war, whatever the cost. They think that another group of the population is to be exterminated for the good of the whole world. So if you have a strong conviction, a strong sense of necessity, probably the call of rule of international criminal law won't be heard. Other problem, some leader figures don't really have a plan B. They don't think, most probably Hitler didn't think, there could be a risk of being convicted of starting the war, because in the Briand-Kellogg Pact there were some indices to that, and because after World War I, in the Versailles Treaty, there was the idea of actually putting Kaiser Wilhelm on trial. So leader figures usually don't really prepare for failure. If they are really convinced of what they're doing, they might not be very open to international criminal law. And for the other ones, we have a host of problematic factors, usually summed up as problems of macro crime or macro criminality. Crimes are committed within state structures and within an apparatus of power, where we have a division of work. We have segmenting of knowledge. We have structures of command, and all that dilutes responsibility. People will not really feel that they are doing something wrong. So we have situational factors that influence the disposition to act or to commit crimes, and that somewhat mitigate the call of rules. And here the most striking example is the Milgram Experiment, where normal Americans were put in a situation where they had to administer electric shocks to a person for a so-called learning experiment. And just because an expert in a white gown that posed as a doctor, psychologist, told them to do that, they did that. Afterwards they were shocked, but in that situation they obeyed. And this works most probably with everyone. There was in the few years ago there was a study in Poland.
Professor Fiolka?
Yes?
If you can finish your lecture, because you have more 5 minutes, it'll be okay?
Yes, that's
Yes.
2-3 minutes will be okay.
Thank you very much, sir.
Then in war crimes, decisions are taken under pressure. People don't really have time to act. They don't really have access to information. And if it comes to specific, to the mechanism of international criminal law, of course you have the problem of selectivity in application of norms, and the problem that still large actors on the political scene are not taking part in the International Criminal Court. There are some further risks and side effects making the idea of protecting, for example, the environment with means of international criminal law problematic. First of all, because you cannot really prove the effect, there is a risk of inflation of criminal law. Criminal law is more used, penalties become more severe, and procedural guarantees tend to be reduced because you think, well, maybe we just don't have enough of it. Then if the definitions of crimes in order to protect human rights become blurred, the credibility of international criminal law could be at risk. And if we go, for example, to an extension of the field of application, for example, protecting the environment by means of international criminal law, then there could be a risk that, for example, if you perceive the concept of ecocide, for example, excessive deforestation, as an utterance of moral entrepreneurship, or also as an economic risk to states and to businesses, this could lead to states actually shying away from international criminal law or institutions of international criminal law altogether. We have seen those tendencies because of the selectivity with regard to Africa, and we could also see this with some kind of extension of international criminal law. So that's it. Thank you very much for listening to me excessively, and yeah, that has been my presentation for today.
Thank you very much, Professor Fiolka. Very interesting lecture, and of course we are all learning about international criminal laws, and of course later on perhaps we will have a little time for a little debate, and of course I would like to make you a few questions because I got very interesting about your issue, and of course just to understand better what you said in your lecture. So thank you very much, Mr. Fiolka, and so we are going to pass for the next lecture, and we are going to call Professor Edita Figura. Is a person that I don't know in person yet, but of course we shall have an opportunity to receive you at our university. And I was attending your last lecture in an international seminar that I got very interested in your topic, in your issue. It was the same for Professor Carol. It was the same. So it's very interesting how internet gives opportunity for all of us to know each one, and of course to talk and plan for the future. So it's very interesting. Poland, I never visited Poland. I never have been in Poland, but I know it's a very beautiful country, full of history, of course, a Catholic country for origin, and I know that Cracovia, it's a beautiful city because I have a friend that got married with a Polish woman, and when she visited Brazil, I had an opportunity to take the couple for a historical city nearby my homeland, in my home city, and I talked with her during all day long. So I learned many things about Poland. Very hospital people, very nice people, and of course in the south part of Brazil we have Polish immigrants. We have descendants of Polish people in South Brazil. Well, Edita, you are going to talk for us for contemporary challenges of consumer law in times of pandemic COVID-19. You have about 25-30 minutes for your lecture. Please be welcome, and we are all going to listen to you.
And thank you very much for invitation to this seminar. Unfortunately, I have never been to Brazil, so hopefully in the future it will be possible. Of course, we invite also to Krakow. This is university city, so I'm sure that also interesting to visit for tourism, but also from a university side, we have a long tradition, so it can be fruitful for all of you. And hopefully when the pandemic will finish, it will be possible to meet in person. So I was asked to prepare the topic concerning contemporary challenges of consumer law in the time of pandemic. So the focus of my presentation will be from European Union perspective. First of all, I will present the model of consumer protection in the EU. Then I will pass to most problematic aspects in the situation of pandemic. So what is the situation of contracts with consumers, especially in the sector of travels and in the sector of tourist contracts. And then I will also present how is the situation from the perspective of unfair business to commercial practices. So those situations that are caused by pandemic, but without contractual relations. And then I will also focus a bit on the procedural aspects of protection of consumers. So first of all, starting from the model of consumer law in the European Union, this model that was introduced in the European Union is the model of informed consumer. So in order to equate the information asymmetry between professional and the consumer, the provisions should allow the consumer to get information about the contract and then take the decision either to be a party to that contract or not. So we don't treat the consumer as a stupid consumer. We think that if the consumer will get information, then it will be possible for this weaker party to take the right decision. The consumer from perspective of EU is a natural person, and this natural person should act outside of the scope of its professional or business activity. Mostly consumers are protected in EU by so-called directives. This is the type of legal act that is directed to member states. So European Union creates directives and then gives time to member states to implement those directives into national laws. On the contrary, the other legal instrument of EU is so-called regulation, which is applied directly. So directed to individuals. On the contrary, in consumer law, mostly European Union uses directives. So there are some exceptions, but this is this most typical instrument. And therefore, the national laws may vary a bit from country to country because of that, that way of this instrument from also in the territory of EU. Nowadays, also EU sometimes uses so-called directives that have maximum level of harmonization. What does it mean? It means that the member state cannot change, cannot give more protection to consumer, cannot give less. But still, member state has to implement those rules into national law. So this is from the construction of EU consumer law. And how does it function in the pandemic time? It is already more than a year. At the end of January of 2020, World Health Organization already announced that we have public health emergency. Then on the 11th March, the state of pandemic was announced, and still, unfortunately, going on. In Poland, it was a bit later. On 14th March, we have the threat of pandemic, and then on 20th March, the state of pandemic, 20th March of 2020. So each member state also in this sphere of health has their own competences. So, for example, different measures can be taken in Poland, different measures can be taken, let's say, in Germany, in France, etc. So here, member states may introduce different mechanisms to protect against this difficult health situation. So going into the first major part of this, what I wanted to present you, so contracts. So consumer law doesn't, this EU consumer law doesn't cover all the sphere of consumer contracts. The EU regulation is so-called fragmented regulation. These spheres that are supposed to be the most fragile spheres are covered. So, for example, the general contract law in different member states still have a bit different rules. So starting from Polish perspective of general situation in contracts, if we have got contracts with consumers that are just impossible to be performed, then the risk in such situation is divided in this way, that if any payment, any performance was made by consumer already, then this performance, because of that, this contract, the obligations expire. The effect is that this performance should be returned, but on the contrary, the consumer cannot ask for any compensation of damage. So even if we would be speaking about theoretically possible to be delayed, the service is just delayed, it's not treated in this way, because if we are in the situation of such circumstances as is in pandemia, that for which the debtor is not responsible, so that this entrepreneur is not responsible for the circumstances of not performing the obligation, there is no possibility that we would be speaking about delayed performance. So the only thing that the consumer may get in the situation of impossibility of performing contract, either because of legal facts, so that the government locked some scope of business, or by a factual situation that, for example, there is no supply of some production and this causes impossibility to perform. The effect is that the consumer may only if any performance was made by him already, like prepaid service, or already he paid for some goods, that he gets this payment back, but cannot get any further compensation. The second possibility is that there is theoretically possibility of performing the contract, but the performance is not reasonable. So that it's in the situation of pandemic, because such that it would not be reasonable to perform that contract. Then from Polish perspective, because this is not totally regulated in EU law, we have so-called rebus in stantibus clause, which causes the possibility to change the relations, so that because of some excessive difficulties, or that the result that the contract would actually result in some gross loss, then theoretically this is the competence of the court, that the court may just ratify the manner of performance of obligation, or the amount of the benefit, or just decide on termination of the contract and some settlements. But parties may also here conclude changement of the contract, but here both parties would have to then agree. So if they don't come to agreement, then each of them has the right to ask the court to decide on that case, which of course is not so short way to solve the problem. In the sphere of this regulation that is covered by EU law, so basically I would like to focus the travel market here. We have actually here exceptionally in airlines sphere, regulation number 261/2004 that concern compensation assistance to passengers in the event of denied boarding and cancellation or long delay of flights. So this sphere, actually the division of risk in the situation of like pandemic cost, for example, cancelling of the flight, as that that the passengers have the right for reimbursement, and in such, or they may ask for rerouting in this case. So they can instead of getting money back, they can ask for later ticket. They have also here the right to care if let's say the flight was cancelled in between. They already took one flight and the second was cancelled. So here is also that regulation. And theoretically, this reimbursement, if they want reimbursement, should be in 7 days. So it's quite short time. Payment can be either by money like cash or bank transfer. It can also be by bank orders, checks, or if the passengers will sign for such agreement, also he may get some travel vouchers. And here, basically, in this sphere, it's said that if we have such extraordinary circumstances that would not have been avoided by even if all reasonable measures have been taken, then the passengers may not ask for additional compensation, like if he, because of the canceling of the flight, incurred some additional damages. So then it is excluded. So this Article 5, Section 3 of that regulation here was applicable. So in the situation of pandemic, so that the risk, as you can see, is also divided. That of course passengers, if their flight was, for example, cancelled, they can get a reimbursement, but on the other side, they cannot get additional compensation. How did it work in practice? Unfortunately, it was not, because of this not normal situation that in travel sphere, up to 90% of all normally performed travels were cancelled or changed. The effect was that actually that passengers had to wait really for months to get their money back, and some travelers, some travel entrepreneurs in this airline market also were making here difficulties to get the reimbursement. So on paper it looks very nice, but in the situation of pandemic, it didn't work in practice so well. In the sphere of package travels, which is also covered by EU law, there is a directive, so this instrument has to be implemented into national laws. It's number 2050/2302 concerning package travel. And there is a similar regulation. So also, if there is unavoidable and extraordinary circumstances, then in the effect, it's not possible to get the compensation for damage. But of course, the client of such travel office has the right to get the money for prepaid holidays or for prepaid package travel back. Here, the deadline is a bit longer, it's 14 days from the moment when the contract is terminated. And what happened, for example, in Poland, we had a statute from March 2020 about combating this COVID-19 pandemic, and there our legislator introduced the withdrawal from the package travel that is effective after 180 days from the notice of a traveler about the withdrawal. So actually that when the notice came to the office, and then there was 180 days from that moment for termination of that contract, and from that moment, after 14 days, the travel office had to pay back. So, and actually, European Commission here found that it's actually contrary to EU law, this way to protect the entrepreneurs. In the end, Poland still have this Article 15K in that statute, but also in October 2020, the so-called tourist fund of back payments was introduced, and here from that state found the reimbursement for that customers of travel office was paid to them. So here, actually, as you can see, also the risk is divided, but because of this massive situation in all market, in practice, it was not so easy to get from the particular travel office the money back. how is the situation in delegate sphere? So here we have also EU directive. This directive, as already from as all which I'm discussing here, it's for the pandemic, and there in this directive against unfair business to commercial practices. This is Directive 2005/29, and we have there, first of all, general clauses that allow, in situation of misleading actions of entrepreneurs or aggressive actions of the entrepreneurs, ways to stop such behavior. And there is also annexed with list of black practices, like, for example, if its product is presented falsely as being curable, it's number 17 of that list, or that as there's an announcement that products are limited in time, so that the accessibility will be limited in time, which is not true. It's, for example, number 7, or that the product is presented such by such inaccurate information that making the consumer to buy it. It's number 18. So there are some black practices also that could be applicable in the situation where some products were presented as some cures for this illness, or that they will prevent spread of the virus, although it was not true, and that products mostly were offered by internet. So basically, because of that, European Commission as well as the states addressed operators of such internet platforms to react in this way to block such not true such products that were contrary to this fair commercial practices, so that they were that they were misleading consumers, or they were creating false impression on them on the basis of such obligation of due diligence that is also in this directive, and additionally in so-called e-commerce directive. And actually it worked that very many offers, for example, by Amazon or eBay, or in Poland, Allegro, they were just blocked. And in this way, this law, these theoretical provisions actually were put into practice by this cooperation between officials and operators of internet platforms. So here, in the sphere of e-commerce, actually, such offers, of course, arrive all the time, but because of that possibility to cooperate with internet platforms, most of them, they are blocked. Here, the other problem is also digital exclusion of some consumers, which can be seen in pandemia, but well, from legal point of view, it's difficult to make some influence. So actually, as you can see from this, what I presented, that basically we have got in our legal system, we have got instruments to protect consumer in these times of pandemic. COVID-19, we had Spanish flu, around 100 years before. So also there are some experiences that already were introduced into law. But from the perspective of law, actually in action, so from this how the procedures from especially in this sphere of travel market, well, this causes some thoughts about to rethink maybe this how to actually implement those rules into practice. And additionally, as those directives that I was speaking about, all of them, they introduce so-called maximal harmonization, so another name, full harmonization, that national states cannot just introduce different regulations, like in as this Article 15K from Polish statute is the example of different introduction in order to protect actually not consumers but entrepreneurs in those difficult times. It's the question of actually, although there is such, in some of them, such possibility that for public health emergencies, for public health, it's possible to make some changes. But is this maximal harmonization really works in such difficult times well? So in theory, although there's nothing more practical as good theory, so theory is not so bad in a consumer sphere, but as always, law in action could be better. So thank you very much for the possibility to speak to you, and hope to receive some questions about my topic. Thank you very much.
Thank you, Professor Edith Figura, and very interesting topic. I teach consumers law at University of Itaúna, and it's very interesting. Our consumer law is from 1990, so we have almost 30 years of this consumer law. Well, I would like to pass the word to our colleague, Professor Beatriz Souza Costa, for your comments. Just a brief comments, about 3 or 4 minutes. Please, it's up to you.
Okay, thank you very much. Firstly, I have to thank you all. Thank you to having me here. And I have 2 comments, very brief, to Professor Gerhard Fioca, about your lecture, International Criminal Law and Human Rights. And it's a curiosity for me, and I think the people that are hearing you. Just an example of criminal about environmental law. Do you have some, just to show us how it occur in Switzerland? And Professor Edita, this is very nice to hear you, the problems of the consumer in Poland, and maybe in Brazil it's occur a little bit equal when related regulations, long flights, or even inside of the country. We have the same problems of the tickets. Sometimes we receive reimbursement, sometimes not. Sometimes we have later ticket too. So I think in these times of COVID, everything is changed. The weak side, of course, is the consumers. And I think it's very nice here the context of Poland too. Thank you very much for your lecture and to showing us what is happening there in your country. Thank you very much for Professor Gerhard too, of the nice lecture. Thank you both.
And Professor Beatriz, it's a question, if you like to direct to Professor Fiocca or
yes.
Edita?
Just if he has objectively, I don't know if he has now, the example of criminal of environmental.
Yes. Well, Professor Fiocca, 2 minutes, 3 minutes.
Well, I can be quite brief on that one because actually the environmental, there is not a whole lot of an environmental crime on a large scale going on in Switzerland. It's a relatively small country, and it's also a country where relatively early there has been some kind of sensitivity towards the environmental media. So the protection of water, the protection of the forests and everything that is very much regulated, but I think it's predominantly regulated in the administrative law. So you have relatively strict procedures on building, you have relatively strict procedures, relatively strict law on what pesticides you may use, on all those things. And so I think the protection of the environment in Switzerland is focused on the administrative law.
Okay.
There are, of course, criminal law dispositions in different acts on the environment as well. There is an act on the protection of the environment, act of the protection of the water and everything. And of course, you do have those crimes, but they are relatively rare in comparison, for example, to road traffic or things like that. Of course, if you put anything damaging into the water, there is a criminal penalty. The problem is if you actually have something disastrous going on. For example, we had 30 years ago, we had Schweizer Halle. There was an accident in a chemical plant, and all the fishes in the Rhine went dead because water from extinguishing a fire went into the Rhine, and there was environmental damage. But then you usually have relatively minor mistakes of someone using the wrong valve or something, and then it's really hard to put criminal responsibility on that. You have an immense effect, but you have a relatively minor fault. So also here, criminal law probably is not the answer, but we have a relatively strict system on enforcing rules on building, for example. In the industry, we have it's more in the administrative law than in criminal law.
Thank you very much, Professor.
And Edita, please.
I would thank you very much also for your comment. Actually, in this from perspective of this EU regulation, this 261/2004. Which is now in force, this consumer has the right to choose if he or she wants reimbursement or rerouting of the travel in the sphere of at least of the aircraft travels. This is theoretically the right of consumer here to choose, but in practice, it is usual like that they sometimes they have no, in practice, no real choice. But the law is like that, and EU Commission also issued a special recommendation in May 2020 in which situation, for example, vouchers can be offered instead of money. So that in order to stop practices of just entrepreneurs in the sphere of not only aircraft but mainly in this holidays or travel sphere, when it's possible to just offer vouchers. But how actually it was applicable, it's also difficult to tell. But the recommendation of Commission is not binding. It is such instrument that it's a soft instrument. It's not binding instrument. But as we know, not only consumers are touched in those times. So this is also have to be taken into account. Thank you very much.
You're welcome, Edita, and we are all very pleased to listen to both of you. And going next, we are going to call Professor Karol Rizowski, I think, more or less, the pronunciation, I think it's got better, Rizowski, right?
More or less.
More or less, well.
The last part is good.
But you forgive me because I'm foreigner, so please forgive me. But Professor Karol is going to talk to us about fundamental right to property in Polish law. As Professor Edita Figura, I knew Karol on internet during an international seminar with Professor Angelo Viglianesi, and of course we have common friends, very common friends, and I thought, well, I'm going to invite these two Polish professors, lecturers, and of course we have a lot to learn about Poland, about European Union. I think it's very important. Language has been always a great barrier between our countries, but especially in Brazil. I think now it's time for us from the universities start to talk in English, to write in English. Of course, we have problems because we are not speaking natives as well as all of us, but English language, it's the university language. We can understand each other. So it's time for the strengthening between our universities. So be welcome, Professor Karol, and as I told before, we are going to invite you in person to come to our university as soon as this pandemic situation finishes. And you will have your tree at the University of Itaúna. So if you have time to time, you'll be obliged to come here to visit us and see your tree. So you have the word, Professor. It's up to you.
Thank you so much, dear professor, ladies and gentlemen. I'm honored to be here with you. Thank you for the invitation, for the opportunity to deliver this speech, and for the opportunity to plant the tree. I will probably name it Carlos. Yes, so it's Karol in in Portuguese, Carlos. Okay, so I have the hope that the internet will be okay, because one of the side effects of the pandemic in Poland is that older people use many times the internet. Now I'm using the cable, not the Wi-Fi, because on the beginning of our meeting I have the problems with the voice and with the video, and I have the hope that now everything will be okay. So I will begin with my lecture. Okay, so the fundamental right of property in Polish. There are two sources of this right in Polish. First, and the main definition of the property right of ownership is in the basic act of the Polish civil law, Polish Civil Code. In the Article 140, this provision indicates the area of ownership rights. According to this provision, within the limits set by the law and the principle of community life, an owner may, to the exclusion of other persons, use a thing in accordance with the social economic purpose of his right, and may in particular collect the profits and other revenues from the said thing. Within the same limits he may dispose of the thing. So we can see there the two basic ingredients of the property right. So the right to possess and the right to use, like in the other countries' system of law. Okay, what about the right of the possess? It should be understand that actual possession of a given thing, and the right to use is the ability to derive benefits from things, including benefits, natural benefits, like the, for example, apple from the tree, or income, like legal benefits resulting from concluded contracts. It consists of possibility of processing an item, connecting it with another, or even destroying it. What else? It could be disposing to another entity under the contract of sale, exchange, donation, another legal title, the right of renounced ownership or transfer under any legal title. The right to dispose also means the right to transfer ownership or derive benefits from things, the right of encumber the property based on obligation, agreement, or burden with a limited property right, such as mortgage or easement. Okay, there are some provisions in the Polish Civil Code which make some restrictions in this after-mentioned area. But the fundamental regulation about the property right in Poland are based in the Polish Constitution from the 1997. So ownership, including ownership of the real estate, which is the most common picture of this right, as well as the right of inheritance, is in Poland protected by the Constitution. However, the provisions of our Constitution are the heterogeneous. This is because of their location in the constitutional law and how they are formulated. So their catalog consists of both regulations in the form of some main principles, provisions expressing subjective rights, and provisions constituting procedural guarantees for the implementation of the former. These regulations are under the control by the Polish Constitutional Tribunal Court, and there are many cases in which Polish Constitutional Court make their speech and give their statements about the right of the property, for example. So the first group of provisions includes Article 20 and 21 of Polish Constitution, which are located in the Chapter 1, which has the name Basic Law of the Republic, with a set of basic principles defining the nature of Polish state, as well as the value and priorities on which are based the Polish state. So the Article 20 makes private property one of the pillars of the social market economy, alongside freedom of economic activity, solidarity, and cooperation between social partners. In turn, another article, Article 21, formulates the principle of protection of property and the right of inheritance as one of the principles of the state system. This is in the first paragraph and allows the exploration only for public purposes and for just compensation. This is stated in the second paragraph. On the other hand, an explicit recognition of ownership as a public subjective right is included in the Article 64 of the Polish Constitution, which are located in another chapter, second chapter, which is named the freedoms, rights, and obligations of the persons and citizens. By this provision, this 64, the legislation grants everyone the right to property, other property rights, and the right of inheritance. Further, this provision stipulates that the values, such as property and inheritance, are subject to equal legal protection for all, and the ownership may be limited only by the statute and only by the extent it does not infringe the essence of the property right. So after the communist time, now all the property rights are equal. Before nowadays situation in the communist time, the property of the state has more power than the property of another legal entities. So due to the formulation of this profession, we can see as well how a big role is handed of the judicial power, especially to the Polish Constitutional Tribunal and the Polish Supreme Court, which makes decisions about the civil cases. For example, the criminal as well, but we are speaking about the property right here. Doubts may arise from the mutual relation between the 21 and the 64 article of the Constitution. It seems legitimate to assume that the first one of them, so the 21, was formulated in terms of duties and obligations of the state, whilst the 64 expresses specific subjective rights. This thesis about the purely objective approach to property is, however, contradicted by the position of the paragraph 2 of the Article 21, regulation of the institutional exploration, which cannot be separated from the sphere of subjective rights of an individual entity. This is convincing because the provision has no equivalent in the content of the Article 64. It therefore means that the paragraph 2 of the Article 21 is a direct source of the right to fair compensation in the event of the expiration and is respected in more detailed provision of 64 provision of the Constitution. There were some opinions about these articles given by the Polish Constitutional Tribunal, and for example, in the judgment from 1999, the Constitutional Tribunal stated that the norm expressed in the Article 21, paragraph 1 is one of the fundamental principles of the political system of Republic of Poland, which results from the fact that this provision was included in the first chapter, which was named the Basic Rights of the Republic. I would like to shorten because this decision of the court is on the whole page. So maybe with regard to the protection of the property rights, are limited property rights, such detailed norms are contained in the Article 64 of the Constitution. So the Polish Constitutional Tribunal assumes that the regulation of the Article 64 repeats some directions from the Article of 21. Due to this judgment, there is opinion in the literature that the light of the Article 64, the establishment and protection of property rights, therefore the obligation to the legislator. And by myself, I agree with the opinion that although the obligation of legal ownership protection is vested mainly in the state authorities, other entities, including private ones, are also obliged to comply with it. It is logical. For example, for me, okay? Regardless of the indicated interpretation difficulties, it is clear that the Constitution makes the protection of property rights and the right of inheritance one of the basic principles of the system. By guaranteeing the right of ownership, the basic law allows expropriation, which means deprivation of the property only for public purposes, as it's specified in a statute in the Article 6 of the Real Estate Management Act, and for fair compensation, which means not only the equivalent of the item, but also additional costs related to search and purchase for another replacement property. Exploration of real estate may take place only for the benefit of the state treasury or local governments, so no private entities here. So we can see that the institution of exploration was created by the Polish legislator in the manner of avoiding the harm of the essence of the property right and has its legitimization in the public interest. So the interest of the society as the whole, not the particular person or the particular company from the state. It is worth also paying attention about the provision 31, paragraph 3 of the Polish Constitution. According to it, any limitation upon the exercise of constitutional freedoms and rights may be imposed only by statute and only when necessary in a democratic state for the protection of the security or public order or to protect the natural environment, health, public morals, or freedoms and rights of other persons. And of course, such limitations shall not violate the essence of the freedoms and rights. So now we can see that there is also Article 64, paragraph 3, and this article set out the principles and conditions for permissible interference of the sphere of the property rights, namely the requirement of statutory basis for such interference. So only the Constitution and the statutes, not the legal act of the lower power. Okay, moreover, in each case of statutory limitation of ownership right, it should be examined whether they do not violate the principle of proportionality, which means whether they are appropriate from the point of the view of intent purpose, the principle of adequacy, whether they are necessary, the principle of necessity, and whether they are selected in such way to make the least burdensome and they make them most bearable. So the principle of proportionality sensu stricto. The prohibition of violating the essence of the law was repeated twice in the Constitution, as well in the Article 31 and 40 and 64. The Polish legislator took advantage of possibility of the statutory limitation of property rights, which are allowed by the provisions of the Constitution, and I will make some examples at the end of this speech. Okay, in the judgment of December 1999, the Constitutional Tribunal stated that the violation of the essence of the right of property would occur if the introduced limitations concern the fundamental rights that make up the content of a given right and would prevent the right from fulfilling the function that the legal order based on the assumptions indicated in the Article 20, which I mentioned before. Thus, according to the Polish Constitutional Tribunal, we are dealing with a violation of essence of the right to property when legal regulations, although they do not abolish the property itself, but in practice make impossible to use it and perform it with its function. The constitutional guarantee of ownership also results in positive obligation of the state, such the creation of precise legal and institutional rules for functioning of property relations by shaping the legal basic institutions that specify the content of the property right and defining its boundaries. And on the procedural level, the establishment of procedures and legal measures ensuring the protection of property right and other property rights. And as I mentioned before, the Constitution from 1997 does not mention the types and forms of ownership, adopting a concept that one property covers all forms. It expresses the contemporary understanding of property, which not only is economic value, but also a constitutional principle, a legal institution, and the element of human rights regulation. Property is not absolute value according to our Constitution. Its limitation or even exploration is permissible, and the admissibility of such a restriction is made dependent on the statutory regulation by the Polish Constitution. This allows for the restriction of ownership in a specific case by the Parliament as a representative of the sovereign in a manner meeting social expectation and procedure subject to a certain requirements as it to complement and in compliance with the Constitution. Okay, maybe I can omit this because it will be too long. Okay. I could add it that even though the Polish Constitution, there is currently no types or forms of ownership, but on the lower level in the statutes, so in the acts, in other words, there are some restrictions such as immovable properties acquisition by Foreign Act, with some exceptions for the foreigners who are the citizens of the state of the European Union or European Economic Area or the Swiss Confederation. In the act of shaping the agricultural system, restriction on trading in agricultural real estate, and in the act of Real Estate Management Act, which makes additional provisions and obligations for the state and local governments when they want to buy or sell the property. Okay. It should be noted that the Polish constitution includes also the Article 2091, paragraph 2, which states that an international agreement ratified upon prior consent granted by the statute shall precedence over statutes if such an agreement cannot be reconciled with the provisions of such statute. So we named it as the European Union Clause because if agreement ratified by the Polish Republic establishing an international organization so provides, the laws established by it, so by the European Union, for example, shall be applied directly and have precedence in the event of a conflict with our laws. They are also the basis for the implementation of potential restriction of the property rights, which will be introduced based on the international agreements which are binding by Poland. Pure consent expressed for the ratification of such agreement in the form of the states who are obliged, including so the European Union law, which have the priority with the conflict with the Polish law. The European Union law do not have the priority before the Polish constitution. So this is the construction of our legal system. Okay. Obrigado per atención. Thank you for attention. Thank you.
You're welcome, Professor Carol, and very interesting your topic. And of course, now I'm going to look for the Polish constitution, of course, in English or in another language, just to read about the topics that you talked to us. Of course, property, even in the Brazilian constitution, we have the social function and also the environmental function of the property. Both works together in sign of the limitation of the property, of the law of the property. It means it's not absolute, but it can be mitigated. Well, of course, we have much to learn about this topic concerning to Poland and, of course, to the directives of European Union. But very interesting. Well, I would like to call our colleague Renata Mantovani. I think our colleague from our university. She'd like to make a brief, a very small commentary. So, Renata, can you hear us? Because I can't see you now. Oh, okay. So, it's up to you, Renata. She has some small commentaries, very brief. And Professor Renata is our colleague of our master's and doctorate master's degree at University of Itaúna. So, Renata, it's up to you.
Boa tarde a todos. Good afternoon. Thank you, Professor. I would like to say that it's an enormous pleasure to be able to listen to precious lessons. We are very, very glad for this. Thank you so much. And I was very thoughtful about the lecture of Professor Gerhard Fioca about international criminal law, a topic that I'm especially interested in. Actually, I love this theme. And in this Thanks. I would like to hear you about your opinion about the indiscriminate use of genocide, especially at the present time. Considering the criminal type and its elements, especially in the face of international jurisprudence about intentional and the groups, something like this. Just an idea about the elements of genocide. Thank you and congratulations about the lectures. Thank you, thank you.
Thank you so much. I think that the concept of genocide has been established for a relatively long time, and now we have some contours of that concept. The advantage of that is that we have a relatively clear vision of what genocide is. The downside, just to say, is we have always this specific element, a specific element that you need to, that the acts need to be destined to annihilate a specific group. And in the past, we always had the problem that people say, well, we didn't have that specific intent. Well, according to the groups, in international law, in the Genocide Convention, in the Rome Statute, we have a limited set of groups that are included in the type of genocide. So we have racial groups, though races don't exist, but still we have racial groups, we have ethnic groups, and we have religious groups. And this somehow is dating back to the 40s, 50s, one can say. Now, in Swiss criminal law, this has been extended to social groups and to political groups. And this extension of the concept seems quite problematic to me, because we have an idea of what, I mean, already ethnical groups are really a tough concept, because we have seen in the Rwanda jurisprudence that there with Hutu and Tutsi, it's really hard to distinguish, and it's really hard to say why those would be distinct ethnic groups. So already there, the concept is tough to use. But but if we go to social groups, then it really goes too far, and I think this might be a problem to the application of and to the credibility also of the concept of genocide. And I also think that it really puts too much emphasis on the concept of genocide, because we also have the crimes against humanity, where a lot would be more easily included. So my fear with regards to the protected groups is that it somehow is watered down and it becomes blurred. What I think the groups we have are already difficult to manage sometimes, but if we go to social groups, it really becomes relatively unclear, and there is really a lot of marginal appreciation in the jurisprudence. So I'm skeptical about extending the concept of genocide.
Thank you, Professor Fiocca. And what about contempt against environmental situation? Do you think that it can be, how can I say? I mean, looking for the correct word, but crimes against nature, against environment. How is your opinion about if these crimes can be promoted to genocide crimes?
I am, as you may have sensed from what I was saying, I'm very skeptical about that. I'm very skeptical about that for several several reasons. I mean, the main one is that it can be really hard to actually delimitate what level that should have, what level of gravity, what type of interference with the environment. So it's really those who promote the crime of ecocide. There is now a group of lawyers really promoting that as they want the crime of ecocide to be included as a fifth core crime, but they are promoting this all the time, but they haven't come up with with an exact wording yet. So I think that might be a tough one. That might be really a tough one. And as I said, going beyond the core crimes, the anthropocentric core crimes we have, might be or might put the system of international criminal justice at peril, because it might be seen as an even more political vehicle as it is seen now. It might be seen as some type of moral entrepreneurship, because we do have the environment as protected object in war crimes. There, it already is. So if you have a large impact on natural resources, on the environment in a war, destruction of natural resources, it's already there. But saying, well, actions against the climate, for example, as core crime, or also the question, I know that in Brazil the question of deforestation is very, very virulent, and I'm skeptical if at this time it will be possible to come up with a really clear-cut definition of ecocide. And if we come up with a definition that is problematic, it might be a risk to international criminal justice as a whole.
Thank you, Professor Fioca. Very interesting. And of course, this topic, this issue, we shall invite you to continue this conversation because it's very interesting. Professor Mantovani de Lima is a specialist in this area, in this topic of international war conflicts. And of course, we are all very interested about it. But all lectures are very interesting because we have about this criminal part with editor about the consumer's law. I think it's very interesting topic because we don't know about Polish constitution, better saying, and the directives of European Union. I think it's very interesting. I think we have also a lot to talk about. And with Carlos in Portuguese, we have, yes, because it's common to our legal systems, because Poland, I think, and also Brazil, we belong to the civil law, of course, I think so. Am I correct, Carol? Yes. So it's civil law, not common law, and we have much in common. So yes. We have a lot to discuss, to talk about. Very interesting. I also would like to invite our colleague Beatriz Souza Costa for if you want, to make some commentaries, because Professor Beatriz is our academic partnership. So it's an academic partnership that all have the right to the word to talk. So please. Oh, I think you're... okay. Yes.
It was closed. Okay, I think it's so interesting, all the lectures, and Carol did some about fundamental rights to property in Polish law. And I was a little bit curious about rural or country property in Poland. And can you talk about a little bit how it works, how it, if it are measures to have countryside property?
Of course. There are some restrictions in transferring the ownership of the land. Some of them depends on the kind of the property. If the property is defined by the statute as the rural one, there are some restrictions in transferring the ownership of it. For example, only the person who is farmer could buy it or inherit it. It was very controversial. This statute was changed many times, even before they were passed to life. So before it take force, it was changed and annulled another one. There was some conflict with the European Union law, because there are some, as I said before, there are some provisions, some bonuses we can say for the European Union citizens. So we can say that European Union citizens have almost as the same power in buying in Poland like Polish men. But without this agricultural act, we have another one about the management, and which one is about the, how we can say it, foreign people cannot buy some lands in Poland, especially this one which are located near the Polish borders. For example, Polish people can buy almost everything, but not the agricultural, not the rural ground. So there is the definition if the ground, the land is rural or it's not rural. If it's not rural, everyone from Poland or almost everyone from the European Union can buy it. If the land is rural, only the Polish man, which is the farmer, can buy it. With the, we have two basic forms of the civil right. One is the land, another is the flat. So we don't have the right to house, but because of the Roman law, I could say, Roman law, superficio solo cedit, the ownership of the house is taken from the ownership of the land. So we could have the right to land or right to flat. And all the people, foreign people, could buy almost all the flats, not without the restriction of the border, but with the land, there are more restrictions about buying the lands.
Thank you very much.
You're welcome.
And Professor Carol, and what about environmental laws concerning to property? For example, how nature is protected in Poland, as the proprietor who owns the property cannot use the property against the common well-being of the collective, the common.
Okay, I understand your question. It was something which I indicate with the speech of the Professor Fiolka and your Professor Basil when you talk about the environmental law position in your countries. because in Poland the question is that about this case ecological law is not sufficient. There are very low fines. For example, some private entities put their pollutions to the Vistula, which means the main of our river, and there were very funny fines. It was 200 euro for polluting the whole river. So this environmental law was not adjusted to the situation. And after these cases, but of course there were some fishes which died, all species. So we cannot retrieve them for once again. And now and after this situation, the legislature see the problem and thinking about the changing the law. So the law is not sufficient. The protection is there is almost no protection. And as you indicate, there is the social function of the ownership, but there's no the ecological one in the Polish constitution.
Thank you, Professor. Very interesting. And the last question before we go to Goran Ilik, it's for Edita Figura. Edita, just a small question, just a commentary that I would like to listen. How internet consumer traffic increases in Poland? Of course, we know with the pandemic situation, the internet traffic of consumers has increased on internet. The Polish justice is able to attend all the complaints of the consumers in this case. That's my question. Just a commentary, of course.
Of course. Thank you very much for this question. Actually, the e-commerce from the perspective of consumers, so basically buying goods by consumers, there is the e-commerce directive, which also Polish law was also implemented to Polish law. So here there is already for several years this regulation, and as we could see in pandemic times, this directive makes platform operators this duty to also check if, for example, that what's sold on their platforms, it's not advertised in a way that is misleading consumers. So pandemia, from this perspective, works. The other problem actually here that in Poland, those little claims like this private enforcement by consumers, we have a basis for this, the legal act that is on combating this unfair commercial practices that implemented that directive concerning the same subject is almost not used in practice. So basically we have from administrative perspective, so-called Office of Competition of Protection of Consumers and Competition, and there this office has influence, can from administrative point of view give fines for such practices that are against consumers, against like broader interest of consumers. But basically, consumers very rarely in Poland go to court with their claims. So this, from this perspective, Polish courts are not the fastest ones. They are not so slow as maybe in Italy. We speak about Italian torpedo, but well, they can be said that they are fast. So probably that's why usually consumers prefer, for example, to inform this administrative office and try to work in this way. We have also so-called spokesmen of consumers. So also on the lower levels, like at the level of cities, there's also this public authority to whom consumers may write that their rights are somehow infringed. So they can also here react somehow, but basically usually just by contacting the particular entrepreneur. So actually from e-commerce perspective, mostly this platforms operators here reacted in sufficient way. But consumers themselves, they were not so active. Rather, it was the administration that contacted that platform operators. The second problem with internet is that some consumers are excluded, especially in small towns in Poland, like little villages. Also the problem with pupils. So in some towns it was like that when there's now schools are still locked down in Poland. But it's not the typical problem of consumers that, but how it looked like that teachers just gave what the pupils were supposed to do, not via internet, not via email, but they just were going from house to house to give them this what they were supposed to do. So also from consumer perspective side, there's this exclusion. But it's more a social problem, not the typical legal problem. Yeah. Thank you very much.
You're welcome, Professor Edita, and of course very interesting. And we shall continue our conversation in the near future, of course. Well, I would like to invite Professor Goran Ilic, and we are all very pleased, very glad to listen to you. I may confess that since we began to write to each other, changing emails, I began to learn about Macedonia, your homeland. I began to learn, of course, we know that it's the land of the great Alexander. Alexander was Macedonian, yes. Of course, and a beautiful country. I also cannot pronounce well. You are from St. Clement Ohrid.
Yes, St. Clements of Ohrid in English, or Clement Ohridsky in Macedonian transliteration.
Yes, Ohridsky.
Clement Ohridsky.
Yes, a very difficult name also. And I know that you have a beautiful lake in Bitola.
Ohrid.
Yes. Yes, a very beautiful lake.
Ohrid Lake. Yes.
Ohrid.
Yes. My university is second oldest university in Macedonia, and it is located in Bitola, in southern part of Macedonia.
Oh, very interesting.
Near the ancient city of Heraclea, which is established by the Philip of Macedonia, or the father of Alexander.
Yes, we know the history. Yes, of course. And of course, it's due to the great Alexander that the Greek culture was spread worldwide. Yes.
Worldwide, yes. Hellenistic culture, yes.
Yes, the Greek culture. Well, of course, I know that you are 5 hours ahead of us. I know that it's becoming night at your land, and I would like to pass you the word to talk about memory, identity and nationalism in European regions. Well, once again, I may confess, I admire your homeland. I think the Balkans are a very beautiful region, and I will visit one day. So it's up to you,
You are
Goran.
all welcome. You are all welcome to be my guests in Macedonia and Bitola.
Oh, thank you, thank you. Very kind of you. So it's up to you.
Thank you, dear colleague, for your introduction. First of all, I want to thank you as well for your invitation to participate in this debate. It was very interesting presentations and interesting debate. My today lecture is quite different from the previous lectures. It's predominantly in the area of regional integration because, as you said, the main title of my presentation is Memory, Identity and Nationalism in European Regions. In order to, I choose this topic or I accept this topic in order to argument the notions of memory, identity and nationalism, which are interconnected to each other. Therefore, I decided to present about the Visegrad 4 or V4 and the quest for the creation of a Balkan group in the light of Euro integration process as a topic that includes all of these notions which are composing the title. This presentation covers the two models of regional cooperation process, as I said, the Visegrad Group and the Balkan cooperation embodied in the Southeast Europe cooperation process. Precisely, this presentation derives from my research and comparative analysis of both regional cooperation processes. First of all, I want to emphasize that the Visegrad 4 is founded on the need for consolidation and stability in Central Europe, its emancipation from the Soviet influence, and integration to the Euro-Atlantic structures. Briefly speaking, that meant a return to Europe by acting together rather than singly and competitively. Thus, to create stabilization and security in the region would bring them closer to achieve that goal, and also to unite the Central European countries on their common road towards NATO and the European Union in the past. Initially, this cooperation was established as a group composed of 3 countries, Czechoslovakia, Poland and Hungary. But following the dissolution of the Czechoslovakia, this group has grown into the V4. As the gravity center of this group symbolically was located the Hungarian town of Visegrad. Also, one of the key motives for initiating this cooperation was the hard opposition to the Soviet system. Given such circumstances, and with major support of the West, the aforementioned countries promulgated the so-called Bucharest Declaration, which launched the V4 idea, directed towards the full restitution of state independence, democracy and freedom, and of course, Euro-Atlantic integration of the region of Central Europe. This document declared developing a society of people cooperating with each other in a harmonious way, tolerant to each other, to individual families, local, regional, and national communities, free of hatred, nationalism, xenophobia, and local strife. Based on these values and determination, the V4 succeeded to establish an authentic path for mutual cooperation based on strong commitment to the mutual tolerance, support, and solidarity. On May 1999, the V4 Prime Ministers summit held in Bratislava approved the contents of the Visegrad cooperation, while incorporating the substantive elements of the cooperation and the structure of the Visegrad intergovernmental cooperation, which undoubtedly enabled the creation of an intergovernmental system for cooperation through various forms of meetings, summits, and contacts. On June 2000, the V4 established the International Visegrad Fund as an international organization oriented to the support of common cultural, scientific, and educational projects, youth exchange, cross-border projects, and tourism promotion. The beneficiaries of this fund are non-governmental organizations, municipalities and local governments, schools and universities, but also private companies and individual citizens. And finally, last but not least, is the Bratislava Declaration. The prime ministers of the V4 countries acknowledged that extraordinary significance of the V4 in modern history, established to overcome the division of Europe after World War II and facilitate the integration of their countries into the EU and NATO. So, regarding the research, I concluded several elements which are specific for the V4 cooperation. First of all, this model of cooperation can be treated as an extensive form of regionalism because of the increased shift towards the softer areas of cooperation, most notably in the societal security sector, with a particular focus on culture and education. So far, the V4 remained mainly a consultative political forum because it becomes clear that the Visegrad is not an institutionalized form of regional cooperation per se, with no standing institutions, except the International Visegrad Fund. Thus, the V4 also represents an ad hoc political dialogue. Within this cooperation, there is no dominant actor, and for this reason, I call it plural initiative. While considering the financial sources and resources, this cooperation is partially supported because of the common fund to which states contribute for funding cooperation projects, which can be co-financed. Considering the solidarity and support of the group member, this cooperation is a real regional cooperation process, which can be seen from the example of Slovakian assistance toward its NATO accession. And from the civil society point of view, the V4 is a fully supported regional initiative, affected through the various financial and program activities of the International Visegrad Fund, which beneficiaries, as I said previously, are the numerous civil society actors. Visegrad 4 is one kind of region with its own specificities. Another kind of specific region in Europe is the Balkans. So I made a comparative analysis between these two intra-European regions. As far as the Balkans and projections for the establishment of some form of Balkan regional cooperation, the situation is unclear and very complex to discuss. In that sense, I need to mention the Balkanization syndrome, the Balkanization notion, frequently used to denote the process of nationalist fragmentation of former geographic and political units into new and problematically viable small states. This sentence is definition created by Bulgarian author Maria Todorova in her book Imagining the Balkans. I recommend you to read this book, which is very interesting in order to identify the Balkan reasoning and the Balkan also and the Balkan antagonism. Maria Todorova in this book explained the phenomenon of Balkanization with the following words: to Balkanize means to break up into small, mutually hostile political units. Thus, To avoid or to prevent such destructive national behavior of the Balkan states, several significant regional initiatives were established. One is CEFTA, Adriatic Charter, Black Sea Economic Cooperation, Southeast European Cooperative Initiative, Energy Community, etc., etc. But as a most suitable Balkan regional initiative, which I used for this analysis, is the Southeast European Cooperation Process, which is an original form of cooperation among the countries in the Balkan region, launched on their own initiative. Initially, at the Bulgaria chaired meeting in Sofia in 1996, the Southeast European countries laid the foundations for regional cooperation for the purposes of creating an atmosphere of trust, good neighborly relations, and stability. Later, at the initiative of the Romanian government, this cooperation process was named as Southeast European Cooperation Process. Its members are the Southeast European countries plus Slovenia and Moldova as well. This process is also known as Balkan Cooperation. I call it Neo-Little Entente because it can be treated as a political recipient or successor of the Balkan cooperation models in 1930s, 1950s, or 1980s from the previous century. The constitutive document, or the initial document of this cooperation process, is the Declaration on Good Neighborly Relations, Stability, Security, and Cooperation in the Balkans, adopted on July 7, 1996 in Sofia, Bulgaria. In this declaration, the Balkan countries outline the 4 priorities for cooperation. First of all, regional security, economic growth, social and cultural development, and legal affairs and fight against crime. In the frame of cooperation in the field of justice, combating organized crime and illegal trade in weapons and drugs, and fighting terrorism. Within this, the member states of the Southeast European Cooperation Process declare that to create a Southeast Europe whose future lies in democracy, peace, economic prosperity, and full integration into the Euro-Atlantic structures. The next important step was the adoption of the joint statement by the heads of state and government of countries of Southeastern Europe. This statement once again confirmed the previous values and benchmarks of the CECP, or Southeast European Cooperation Process, but also stressed and their will for pursuing the Southeast Europe cooperation on a mutual and equal basis, in the firm belief that each of us has much to learn from the other. Directed toward the improvement of the CECP, the member states in 2000 adopted the Bucharest Charter, which can be treated as the principal platform for further development of the CECP. This charter more clearly outlined the goals of cooperation and the following tools for its achievement. First of all, enhancement of political and security cooperation. Second, fostering economic cooperation. And third, enlargement of cooperation in the fields of human dimension, democracy, justice, and combating illegal activities. With this charter, the participant states of the CECP once again expressed their strong belief that the European and Euro-Atlantic integration is essential in promoting their common objectives. Each of these goals were also accompanied by specific instruments which gave their implementation a more tangible nature. But contrary to that, I can say that reality requires institutions, and also a political determination for fostering and strengthening the solidarity between the countries. In this case, the political will lie at a low level, which basically are more rhetoric commitment rather than a real political effort in the region. For example, during the Greek presidency of the CECP, several fields were identified as priorities for cooperation among the member states, most of them in economic as well as in home affairs and justice areas, and for this purpose the Greek government prepared an action plan for the institutional enhancement of the CECP. But, frankly speaking, Greece favored more Greek affiliation of the CECP because of its predetermined role on the Balkans as the oldest EU member state compared to other. In this context can be emphasized its hypocrisy, especially in relation to Macedonia as well as Turkey. As a most suitable example, contrary to the solidarity rhetoric, emerged when Greece vetoed the Macedonian accession to NATO at the Bucharest summit in 2008, justifying its attitude with the name dispute as an action which is contrary not only to the commitments of the CECP, but also to other ratified international legal documents, especially the interim accord signed by Macedonia and Greece in 1995. Today, I can emphasize one another example for the non-solidarity of the Balkan countries, and that is Bulgarian veto to Macedonian European integration process because of the Bulgarian-Macedonian clash over the Macedonian history. So, as another example of CEP solidarity or non-solidarity is the maritime boundary dispute in the Piran Bay between Slovenia and Croatia, when the first one, the Slovenia, as then a European Union member state, blocked the negotiation process of Croatia as an EU candidate state. Within this lecture, I feel important to stress that this dispute is not resolved within the CECP institutional framework, but with an arbitration agreement signed by both sides and the President of the European Council, so with arbitration of European Union Council. And finally, in order to reach more effective and more institutionalized cooperation in the region, the CECP participant states established the Regional Cooperation Council, which is quietly functional institution, and the Regional Secretariat for Parliamentary Cooperation in Southeast Europe. The Regional Cooperation Council arises from the Stability Pact and focuses itself on promotion and enhancement of regional cooperation in Southeast Europe and supports Euro-Atlantic integration of the aspiring Balkan countries. Also, its work is directed toward the improving of the mutual confidence between the states as an essential investment in the regional cooperation and acquisition of the sense for regional ownership, because the Balkan countries share mutual memory, share mutual values, and share mutual interests. Today, the mutual interests are embodied in Euro-Atlantic integration structures. On that basis, and on the basis of the conducted research, I can conclude that the regional cooperation process mainly are processes which have many obstacles and difficulties. Moreover, if they are implemented in the Balkans. As I previously mentioned, this presentation represents an analysis of the possibilities for achieving the Balkan Group similar to the V4. So, the establishment of the Balkan Group or more effective Balkan cooperation is not a myth. It is a real challenge which directly arises from the Euro integration process, which requires real efforts, strong political will, and a true sense of regional ownership. Considering the current development of the CECP, it cannot be said that this is a real Balkan group, following the V4 example, because of the obvious lack of the key elements, such as real solidarity, promising political will of the political elites of the countries, and wider connection of the CECP with the civil society actors. In relation to the V4 model, the CECP can be treated as an extensive form of regionalism, starting from its large range of areas for cooperation from all sectors of security, for example, as well as consultative and ad hoc political dialogue, because the CECP is not an institutionalized form of regional cooperation, and its decisions are not obligatory to any of the member states. Also, there are no dominant actors, and for this reason, the CECP is plural initiative. Considering the financial sources and resources, unlike the V4, the CECP is fully supported regional initiative because all the CECP activities, mainly high-level reunions, are financed by the member states. Considering the solidarity and support of the group members, unlike the V4, which is real initiative, the CECP is a declarative regional cooperation process because the solidarity as such is still on a declarative and rhetorical level. As I said in the previous example, the Greek and Bulgarian veto on Macedonian Euro-Atlantic integration, the Slovenian veto on Croatian European integration process, etc., etc. Besides that, the civil society is a very important segment within the both cooperation models. I think on V4 and also the CECP, because it connects the regional cooperation process with a wider circle of actors and with the civil society actors and also with the individual citizens. For example, it would be very useful if only a small part of the CECP resources are invested in the RECOM. RECOM means Regional Initiative for Reconciliation of the Balkans. That means giving a financial support of this citizen regional initiative aimed for a reconciliation of the former Yugoslav region. Unlike the V4, the CECP mainly not support the civil society actors. And from that aspect, it is highly top-down type of regional initiative. While considering the political will of the CECP participants, we can conclude that this process manifests only declarative political will for further enhancing of the Southeast Europe regional cooperation besides the rhetoric of its member states. I can finish this presentation with one thought of the famous Nobel laureate Ivo Andrić about the Balkan people spirit. He said, "Our peoples live past, bitter and empty, among malicious, vengeful thoughts and periodic revolts. One sometimes wonders whether the spirit of the majority of the Balkan people has not been forever poisoned, and that, perhaps, they will never again be able to do anything other than suffer violence or inflict it." Let this thought be a message for the current and future generations, who must recognize the meaning of the regional ownership and mutual tolerance, and to start investing bigger and stronger efforts towards the building of a real, supportive and efficient Balkan group, Balkan integration, which will operate within the European Union system for the sake of the Balkan people and for the Europe as a whole, based on shared memory, shared identity and shared interest. Thank you very much. I hope that I was not. Thank you very much.
Thank you, Professor Goran. Very interesting because we have a lot to learn about the Balkans. About 3 years ago, I had an opportunity to visit Slovenia, a very small country, but very beautiful country. And of course, I could notice that borders problems still remains, especially between
Croatia. Slovenia
yes,
with Croatia.
yes, exactly, with the Croatia. But I think what you said, it's very important because we have to build tolerance, solidarity, and it may show simple, easy, but it's not easy because your topic, your issue is just about memory, identity, and nationalism. It's not easy. It's a very difficult topic.
Of course.
And of course, the Balkans and the countries that belong to the Balkans will build their history. They are building their history to the future. And the most important, what you said, in my opinion, is to work with the next generations for the next generations, for the present, but for the next generations, have a better idea of tolerance and solidarity. And I wrote down the book, I think I wrote correct, Todorova. Yes, correct.
Maria Todorova. The name of the book is Imagining the Balkans.
Yes, I wrote down here, and of course I will try to buy and read about it because I think it's very interesting. Well, I know it's getting late in your countries, and
No problem.
yes, but very interesting. Of course, it's not the first time we are going to invite you all to return, even virtually, because we have here universities, University of Itaúna, Escola Superior Dom Helder of Belo Horizonte. It's a very prestigious institution here in Minas Gerais. We have Caxias do Sul University, which is located in the south part of the country. It's the land of the good wine. Good wine, we can find there grapes, juice, of course, and even champagne. I think the name is not champagne because it's for the French people, but we have very good drinks. And we have also from Faculty of Law Meridional, IMED, Mariangela represents this faculty. So we have various faculties of law and universities here. And of course, each one are going to invite you for separated seminars. Of course, I can foresee the future because I know my colleagues here. I foresee the future. Well, so once again, thank you very much. And as I said before, today it's Gerhard Fioca birthday. So
Happy birthday, Gerhard.
yes, happy birthday. Lots of health, peace, love, money, everything good, of course. And we have Mariangela that also is celebrating her birthday. Mariangela, feliz aniversário. Estou vendo até a sua gatinha andando aí do lado. Ela deu uma passadinha do lado ao seu animal de estimação, né? Feliz aniversário. Oi?
It's my Hellcat.
Ah, sim. I saw the little cat. Né?
Yeah.
Two
God.
cats. I can see two.
They are fighting now. I'm so sorry.
Ok. Não. Mas parabéns, Mariângela. pelo seu aniversário, muita saúde, muita paz. Aqui eu estou apenas falando em português. A professora Mariângela, ela é uma locomotiva acadêmica. Eu nunca vi. She's like a locomotive because she works so hard that it's impossible to make the same things that Mariângela used to make. I can say she is a volcano to work. A real
Thank
volcano. Yes. So happy birthday, and I would like to pass the word for Beatriz, our colleague, Beatriz Souza Costa, for the closure of the seminar. So, Beatriz.
Thank you very much, Dayton. And you give me the honor to do that. I think it's wonderful to be yours. But I have to thank you so much for his invitation to be part of this seminar with brilliant minds. I'm so honored to be here. You don't imagine how honored I am. And I have to another time invited you to be, who knows, together, present in Brazil. We'll be honored to be you here, Carol, Gerhard, Edita, and Goran Ilek. It will be honored to invite you to come to Brazil.
Thank you very much, Beatriz. Thank you very much.
And I have to talk about your lecture. It was so rich, so brilliant, like the others, but I didn't talk about yours. And I learned so much today. You can imagine how, and I think all of us learned a lot today, this afternoon here in Brazil. And we have to thank you so much, your presence, you're giving your time to be here with us. We are very, very grateful for that. You can imagine that. And so I have to close her. Oh, it's not good, but it's so nice to have you. But I know that it's late in Europe, so we have to close. And one once more, thank you all, and thank you, Dayuto, for giving us the opportunity to be together. Thank you very much.
Professor Dayuto, may I say something?
Of course.
I'm so grateful to be here today, and all of these lectures were wonderful. So thank you for this gift of my birthday.
Yes.
Thank you so much. And thank you, Professor Dayuto, to give to me this wonderful gift. I'm so proud to be here with you. Thank you so much.
You're welcome, Mariângela, and it's wonderful to hear your emotional words. Of course, because it's your birthday, we all understand 100%. Well, thank you very much, and also I would like to thank Professor Cleide Galgaro. She's from Caxias do Sul University. As I said, she's here. And of course, we shall have another opportunity to stay all together virtually while we still have this pandemic situation. It's a pity. It's a really pity. I hope that it'll disappear very soon. I hope so. And for us to travel, I think it's very good. I have to know Poland. Poland, it's on my way. I have to know Poland. I have to know Macedonia, Switzerland. I don't know. I was near the border. Many years ago. I was in Haute-Savoie in France. Yes, and I could see the Switzerland, the Swiss border. But Europe, although it's not big, but you cannot visit so many countries, because if you want to know one country, you have to stay in one country. But I will know. So thank you very much, and I would like to give some words for the students. I may ask permission in Portuguese. Eu também gostaria de agradecer os estudantes que aqui se encontram. Eu vejo aqui os meus alunos de doutorado, enfim, a todos aqueles que prestigiaram esse evento, porque é como o professor Fabrício, ele teve que se ausentar, ele pediu que justificasse a sua ausência. Esse evento é para vocês. Ele só se justifica no momento em que nós fazemos para vocês, para que vocês possam enriquecer os seus conhecimentos e abrir as suas mentes para novas fronteiras, que aqui nós temos professor da Suíça, professor da Polônia, da Macedônia do Norte. Isso nos permite que abra a nossa mente, a nossa vontade de aprender. Conforme eu disse, a língua inglesa temos que aprender a utilizá-la melhor. Estamos começando a utilizá-la. Obviamente ela precisa ser melhor, deve ser mais utilizada no sentido de ficar mais fácil a comunicação. Mas temos que começar. Então, esse é o início, é o start que foi dado. Veja aqui o Alisson, enfim, outros alunos. Muito obrigado, né? E que a gente possa estar retornando. Mês que vem, nós teremos um próximo seminário desses encontros e debates. E de 27 a 30 de abril é o nosso seminário internacional. Também trazendo aqui professores da América Central, América do Sul, professores da Europa, professores do Brasil, para que a gente possa estar aqui conversando com eles. Muito obrigado, né? Então, I would like to thank you all, wish you all a good night. Thank you very much for your time to stay with us. It was a very pleasant afternoon in Brazil with you all. So, bye-bye, and see you soon. I will say, see you soon. Bye-bye.
Bye-bye, my friends.
Bye-bye.
All the best.
Obrigado.
Have a nice day and evening.
Yes, thank you.
Thank you.
Thank you and goodbye. Bye.
Bye.
Thank you.
Professor Deilton,
Diga.
olha só, meus alunos do JAC estão perguntando se vai ter certificado hoje.
É possível, sim. Eu só peço assim, uma certa compreensão. Depois eu vou passar o e-mail da secretaria para que eles possam estar enviando um e-mail. Porque como a nossa secretaria ela tá assim, ela começou a funcionar parcialmente, a gente ainda não está assim, em condições de expedir rapidamente, mas é possível, sim.
Tá, obrigada.
Nada, é um prazer.
Obrigada por tudo.
Não, eu que agradeço pela sua presença.
As gatas se matando ali atrás, bem na hora.
Não, foi lindo. Foi muito lindo.
Eu tô no quarto da minha filha que estragou meu computador, daí eu tô no quarto do adolescente cheio de brinquedinho e bicho pra todo lado.
Não, fique tranquila, foi tudo muito lindo, gostei muito.
Eu tinha que agradecer, né? Eu tinha que pelo menos agradecer, né?
Isso.
Obrigada, prof.
Nada, e feliz aniversário, comemore, hoje é o seu dia.
Obrigada, tchau,
Nada, até mais, tchau.